In today's video, I'm going to be looking at the case of David Carrick, the Metropolitan police officer who was recently sentenced for a number of serious sexual offences against 12 women over the course of 17 years. And I'm going to be looking at whether or not he should have been awarded a whole life order after he received 36 life sentences for a number of the charges on the indictment. So I'll be looking at some basic facts of the case. I'll be looking at what a whole life order is and the circumstances in which it is usually awarded by the court. I'll be looking at the sentencing remarks of the judge in this case to understand why a whole life order was not awarded. And then I'll touch upon what might happen in the future in terms of any appeals, either by the defendant or if the case is referred to and taken up by the Attorney General on the basis that the sentence was unduly lenient. David Carrick was a serving police officer who committed multiple serious sexual offences against 12 victims over the course of 17 years. He pleaded guilty to 71 instances of sexual violence and was sentenced on the 7th of February of this year to 49 of those offences. The features of his crime were primarily the use of his position as a police officer to enable his offending, which gave him the confidence to act without fear of consequence of his actions. Included in his crimes were multiple rapes, assault by penetration, and sexual assault against women who feared speaking out because of his position as a police officer. Now, I'm not going to go through the specific facts of the case in detail, but the facts are laid out in the sentencing remarks of Miss Justice Chima Grubb, and I'll put a link into the description for the sentencing remarks. On the 7th of February 2023, Carrick was sentenced to 36 life sentences with a minimum term of 32 years, and then in that time was deducted the time that he'd already spent on remand, which was 491 days. In addition to this, he was also sentenced on one offence to 9 years imprisonment. On 2 other offences, he was sentenced to 7 years. And then on 10 other offences, he was sentenced to 4 years. And all of those sentences will run concurrently to the life sentence and minimum term that has been imposed. So in total, at the end of his sentence, Carrick will have spent a minimum of 32 years in prison before he will be eligible to be considered for parole. And that is not to say that he will be released at that point. This is merely the point at which he can be considered for release. There is a chance that Carrick will never be released from prison if he does not satisfy the parole board that he is safe to be released back into the public. A whole life order is considered an exceptional sentence where the circumstances are so exceptional as to justify the imposition of a whole life order. At the time of recording, there is only about 63 defendants who have been sentenced to a whole life order and are currently serving their sentence in prison. And a whole life order is normally reserved for offences of murder where, for example, there has been a murder of 2 or more people. The murder involves children where there is a sadistic or sexual nature. There's an ideological or political or religious connotation to the murder. There is a murder of a police officer or a prison worker, or that person has previously been convicted of a murder. And in my research for this video, I could only find one example of an individual or 2 individuals being awarded a whole life order for a non-murder offence involving serious sexual offending. So it is absolutely the exception. And in the normal course of events, even for a crime as severe as murder, normally an imposition of a life sentence will be accompanied by a tariff, a minimum term that the offender will spend in prison before being considered eligible to be released. So in the circumstances of this case, 36 life sentences were imposed and the tariff was set at over 30 years before David Carrick can be considered for release. And in the next part of this video, I'm going to look at the sentencing remarks to look at why the judge did not impose a whole life order and instead set a minimum term when sentencing David Carrick. The judge addresses the issue of whether to impose a whole life order in paragraphs 32 to 35 of her sentencing remarks. She focused firstly on the case of McCann, Singer and Khan, which was a case involving serious sexual offending, and the question was asked whether or not to impose a whole life order. It was determined in that case that although the offending was of such depravity to impose a heavy sentence, ultimately the case resulted in the imposition of a 40-year life sentence instead of a whole life order. And of course the judge says in this case that that did not involve the individuals being police officers misusing their position. She did remark on the fact that the prosecution did not seek to persuade the judge that this was a case where a whole life order should be imposed. And in criminal sentencings, particularly where the defendant has pleaded guilty, the prosecution will outline the facts of the case. They will go through the defendant's previous convictions, and they will also go through the sentencing remarks for the offences with which the defendant is being sentenced. And the prosecution will seek to persuade the judge that the case falls into a specific category which would attract a specific sentence. And in this case, and for reasons I don't know, and I make no criticism, and as I was not in the case, the prosecution did not seek to do so, and the judge commented upon that. The judge also goes on to look at the case of Wayne Couzens, the former disgraced police officer who used his position as a police officer to kidnap, rape and murder Sarah Everard. In that case, when it was appealed, he was seeking to appeal his sentence. The court stated that the facts of the case were an absolutely important consideration in this case, and that Wayne Couzens had used his position as a police officer to commit the offending, and that was such a fundamental breach of trust and the circumstances of the case so grave that only a whole life order was appropriate in those circumstances. The judge in this case determined that whilst the case was of the utmost depravity, it did not meet those very, very rare circumstances which would justify a whole life order. So in the end, she decided that whilst the case would attract a life sentence for a number of those offences, the overall sentence would not be a whole life order. In determining the minimum term to be given to the defendant, the judge firstly looked at if this was to be a determinative sentence, that is a standard sentence that you would get in the Crown Court if this was not a life sentence. She has to determine what the starting point for that would be. And in there she determines that the appropriate starting point for a determinative sentence would be 60 years. From there, she then is required to deduct or give credit to the defendant in light of their guilty plea. Now, in this case, there were two different indictments where, firstly, the defendant pleaded guilty at the first opportunity, and then in the second indictment, they pleaded guilty at a later date, but pre-trial. So the judge awarded a credit of 20% to the defendant as a result of his guilty pleas. So the judge, having awarded a 20% credit, reduced the sentence from one of 60 years to 48 years. As the judge is imposing a life sentence with a tariff, the judge is then required to take 2/3 of the determinative sentence after credit is awarded, i.e. reduce the 48-year sentence by 2/3 to come to the tariff that will be awarded as a minimum sentence for the defendant. And that 2/3 comes to 32 years. The judge is then finally required to deduct any time that had already been spent on remand by the defendant and that was 491 days. So as a result of that, the minimum sentence imposed as a result of these multiple life sentences was just over 30 years. So in terms of next steps, what might happen in this case is one of two types of appeal. Firstly, the defendant may wish to appeal his sentence on the basis that he believes that it is manifestly excessive. And what will happen is that the case will be referred to a single judge who will review the evidence of the case, what's known as on the papers. So there'll be no formal hearing. He will just be given the evidence to consider whether or not the case will go forward to a full court at the Court of Appeal, which is usually heard in front of 3 justices. And then they will consider whether or not the case or the sentence imposed by the court is manifestly excessive given the nature of the offending. And they can either quash the sentence and impose a new one, or agree that the sentence was not manifestly excessive and the appeal will fail. And the second appeal will be through either the prosecutor or indeed a member of the public can appeal to the Attorney General to review the case and decide whether to make an appeal to the court on the basis that the sentence was unduly lenient. And I've talked about this in one of my shorts, which I'll put a link into the video. What will happen then is that after one or more members of the public or the prosecution refer the case to the Attorney General, they will look at the case to decide whether or not they feel it is unduly lenient, and then make an application to the court for the case to be considered as to whether or not the sentence is indeed unduly lenient. And it's a careful balancing act for the Attorney General's office, because a sentence may well be a bit lenient, but the legal test is unduly lenient. And sentencing itself is not an exact science. There is discretion that is afforded to judges. So one judge may be left of arc in terms of the number of years that the tariff would have been set, and another judge may be right of arc, and then other judges may be somewhere in the middle. And what the court is looking at is whether or not the case is so far to the right, i.e. so lenient, to be unduly lenient in terms of the circumstances in this case. And the court will do one of 3 things. Either they will refuse to hear the case in the first place. The second thing is that they review the case in front of the full court, that is in front of the 3 judges, and determine that the sentence is not unduly lenient and decide to do nothing. And then the third is that they do agree with the Attorney General and the legal counsel representing them and decide that the sentence is unduly lenient, in which case they will increase the sentence to what they feel is appropriate in the circumstances. Thanks for watching. I hope you found this video informative, even if you disagree with the decision not to impose a whole life order. Hopefully it's given you some understanding as to the reasons why the judge did not make that decision. If you like this video, please give it a like and consider subscribing to my channel. I'll be looking to do more reviews of cases, and I also push out YouTube shorts on a regular basis looking at aspects of criminal law. Thanks for watching.